I've got a question in my DMs related to co-parenting with addicts. Here is what it says. I'm wondering if you can shed some light on how Arizona courts view sex addiction and child custody. My ex's addiction is well documented through a variety of treatment centers, therapists, and there is an open criminal investigation. While he has been open to treatment and recovery in the past, he is now claiming he doesn't have a problem and is not following his treatment plan. We went through a lengthy, comprehensive family evaluation, which included a psychosexual evaluation on him. Dad is not accepting the recommendations of the evaluator, and we are headed for trial. Is there any chance a judge will rule outside the evaluator's recommendations and in the addict's favor? Hi, I am Billy Terrasio, Arizona family law attorney, owner of Modern Law and Win Without Law School. And yes, we are talking about co-parenting with addicts this month. Sex addiction is a tricky one. There is a specific statute on alcohol. There's a specific statute on drugs. The statute regarding sex offenders is 25-403-05. And it says, unless the court finds there's no significant risk to a child and states the reasons why in writing, the court shall not grant a person sole or joint legal decision-making of a child or give unsupervised parenting time with a child if a person is a registered sex offender. In Arizona, if you have been convicted of an offense, then you go on the sex offender registry. And those offenses include sexual assault, child molestation, kidnapping of a minor, sexual contact with a minor, child sex trafficking, child prostitution, child pornography, sex abuse of a minor, indecent exposure, or continuous sexual abuse of a minor. So as you can see, there is no specific statute. Let's say if your husband, I believe it's your husband, or if the children's father, let's say he is compulsive in his need for sex and he's purchasing prostitutes. As you can see, that doesn't make him a registered sex offender. If he is a voyeur, I've had this come up in cases where somebody is a voyeur and they might be charged with voyeurism. At that point, what we have to do is tie the specific facts of this case to your children. So how is the sex offender or the sex addict's behavior a danger to your children directly and specifically? And I've seen courts go all sorts of ways on this. We had a case where the father was a sex addict. They had a small 2-year-old son that they shared, and the court did not believe that father's sex addiction impacted the 2-year-old in any real way. Had another case where a dad was caught trying to solicit a minor. And in that case, we got an emergency order stopping all of his parenting time with his teenage daughter. So the bottom line here is there's no bright line rule of exactly what's going to happen just because your ex might be a sex addict. And some people find that term completely controversial. It's not in the DSM, but it can be a compulsion, and there are treatment groups for it. So it really depends on what your experts say. And that brings me back to your last question, which is, will a judge ever go against the recommendations of an evaluator? The answer is yes. Yes, judges do go against recommendations of evaluators. It is certainly something to discuss with your lawyer, specifically your evaluator, your judge. Always an issue. I hope this helps. If you all have had any experience with this, please feel free to drop it in so that we can all learn from each other.